that once you've been given the job to collate, that job does not end by the first declaration of results. And I think you have reason to revise that, you're entitled to do that. Now, in the conversation we are having, and particularly in light of the Supreme Court decision, we ought to distinguish between what is doing the right thing rightly and doing the right thing wrongly, meaning that there's a procedural question which is at the heart of the conversations here, and which the Supreme Court, I believe, was absolutely correct in directing in the orders that they are taking on this matter, which is that the substance on how the judge may reach the decision to order mandamus may not change, but what is sacrosanct in our democracy is the right to hearing. That persons who are entitled to be heard on the matter ought to have been given the audience to speak to this, which is what we are denied them from doing. And in fact, from the proceedings in the Supreme Court, and the extent to which the High Court judge took to ignore matters that had been brought before his attention were pending before him, I think that very few people would have been supportive of his decision to refuse the NDC the opportunity to be heard in the matter. Now, one of the things that we can agree the Supreme Court has done is, I believe, is a Solomonic judgment. It's a judgment that, for lack of a better word, favors our democracy and enhances the rule of law. It's the direction of a lot of people have been hoping to see from the Supreme Court in years, and I think that everybody will be overjoyed in the way in which it brought clarity and maturity to the decisions that it made. But it doesn't resolve the issue, and I don't think the Supreme Court intended to. It recognized the authority of the High Court to make those decisions and do it so rightly. And so we are back to the drawing board, in essence, that the NDC will get an opportunity to be heard of the matter. But there's something important here, which for even you and I who are interested in the legal question as to whether the Electoral Commission has the legal authority to recollate, that this may not necessarily resolve, because of the manner in which the court has been approached. The court has been approached on a mandamus application. And the mandamus requires that you make a showing that the Electoral Commission has either failed to collate or is refusing, after a reasonable demand has been made on it, or after a reasonable time, to collate. It is surprising to me that in the High Court proceedings, the EC, even though it has not said anywhere that it is refusing to collate, went ahead and did not oppose that point. So when we come back before the High Court, that question is going to arise again, and I think the NDC is going to be happy on that, which is that there's nowhere where the EC has said it is refusing or failing to do a statutory duty. And if there's no failure to, and there's no refusal to, then the mandamus does not lie in terms of how law operates. Now, there's a bigger question as well centrally to this, which is the Commission's persistent recourse to placing the judiciary before a fait accompli, which for me is a strategy that seeks to undermine judicial oversight by putting in place what it considers to be reversible outcomes. And I'm speaking here, one, when it was a state of execution, it went ahead to collate those results. And the last week we talked about, we don't understand the rush. A rush which is not only just a rush, but is also offense law and procedure, which is that you cannot disrespect the courts when it's a pending application to stay. You can't take any actions. Secondly, and as you have pointed out in the beginning, the fact that the EC participated in the process, filed an affidavit in opposition, and yet went ahead to gazette those results. Again, another attempt to place the court before a fait accompli. This series of actions, for me, is something that we need to look at. The liberty with which the Electoral Commission continues to give itself in undermining the judicial process is really concerning, particularly when consistently trust in it is low and when people are continuing to call into question his actions. What happens next as to those series of actions, I don't know. But one thing we are clear about in law, and perhaps here we have sort of an extension of the Grun-Norm principle, that a chain of legal validity of those declared results, and then consequently the Gazette has been broken. The Supreme Court has quashed those, which means that the Gazette, which is based on those declarations, are null and void and have no legal effect. That ought the position of them. And I know a number of people have suggested that the EC can go ahead and submit those gazettes to Parliament, and Parliament ought to respect it. I don't think that is going to happen, unless obviously we see what happens in court.
There are those who actually suggest that the NPP could simply withdraw this mandamus application so that on Tuesday there will not be any application to be moved because those results have already been gazetted.
And I've heard that view before, and I think that, in fact, I have made that suggestion that that possibility could happen, where the NPP could withdraw the application. But the fact of withdrawing the application does not nullify or extinguish the Supreme Court's order that the declarations were null and void. So those declarations that were made on Saturday in particular do not exist in law. The question is whether or not, and then we get back to the same point we have been going back and forth on, whether the EC is entitled to go back and recollate, whether with or without a court order. That question continues to remain alive, but for all intents and purposes, all we have now is the earlier offense declarations, which have not been nullified by any court process, but unfortunately do not have the benefit of a gazette. And in that situation, it will be interesting to see how we navigate if the MPP decides to withdraw them.
So